This podcast is published solely based off the interests of Jacko Law Group, PC, and in no way be construed as legal advice. The opinions shared reflect those of the authors and not necessarily the views of Jacko Law Group, PC. For more specific information or recent industry developments or situations, you should seek legal opinion or counsel. You are hereby notified that any review, dissemination, or copying of this message and its attachments, if any, is strictly prohibited. These materials may be considered attorney advertising in some jurisdictions.
Welcome to Jacko Law Group's Securities Law Regulatory Compliance Podcast. I'm Michelle Jacko, Managing Partner and CEO at Jacko Law Group PC. We created this podcast to break down complex securities law regulatory compliance matters for business owners and professionals like you. Today, we'll be talking about the common themes we've noticed in recent SEC examinations. Our attorneys know firsthand that this past year, the SEC was focused on retirement investors, aging clients, and cybersecurity, and this still remains true. We wanted to touch on the key topics that we've seen during routine exams, suite examinations, and formal regulatory investigations to help your firm prioritize and develop regulatory processes. We'll start off with retirement accounts. The Division of Exams is especially interested in how firms talk to clients regarding retirement. They're also taking note of how firms evaluate what's in each client's best interest and whether all options have been made available. To align with these items, be sure to clearly document your practices, since deficiencies tend to arise with lacking documentation. You should also ask yourself whether financial advisors have been trained to service retirement accounts, as well as what written disclosures have been provided to clients regarding retirement options. These are just best practices to cover your bases. Next, with more people living longer, examiners are keenly interested in how aging clients are serviced. This includes how the advisor deals with diminished capacity, financial exploitation issues, and more. The SEC is mostly curious about whether registrants are fulfilling their duty of loyalty and duty of care when servicing aging clients. In coming to this conclusion, the Division of Exams will observe whether policies and procedures consider the handling of client accounts upon death, client requests for changing beneficiaries, powers of attorneys or trustees, and documenting the frequency of communication you're having with aging clients. Lastly, protecting clients against cybersecurity threats is an increasingly important area for firms to consider. Examiners typically ask advisors whether they've established robust policies and procedures to prevent cybersecurity attacks and protect investor interests. In terms of cybersecurity, we've noticed that the Division of Exams has been keen on whether advisors have conducted a cybersecurity risk assessment to identify cyber threats and to detect vulnerabilities, as well as actions taken to address those areas. Another area of focus is vendor due diligence on cyber controls, as well as vendor responses to cyber incidents. Other areas of interest our attorneys have noticed is an increased focus on ESG investment policies and procedures, how advisors are calculating their advisory fees, and how advisors are complying with new rules, such as the new marketing rule. If you're not completely confident that your firm can address those areas of SEC interest by the time the examiners arrive, an outside counsel can keep you well prepared. At Jacko Law Group, we conduct mock SEC examinations to help you identify high-risk areas so that we can address them immediately. To find out more and to speak with our team, we invite you to contact us at 619-298-2880 or contact us online at jackolg.com. Thank you for listening. We hope you have a great day.